Now, the privacy commitment for Victoria in Australia is exactly the same as the privacy commitment in Milwaukee or wherever else in the world. It's a one-size-fits-all policy that doesn't recognise difference. I'll turn to that issues around health policies in a moment. But look, in the limited time that I have, I wanted to make remarks that can be divided into three key areas. The first is to suggest an analytic framework for framing the debate between the right to privacy and the right to health. The second is to step into the perilous territory of de-identification and re-identification. And then I wanted to make some final, very brief remarks about e-health in Australia. If you wouldn't mind giving me the indulgence, I would ask you to accept a number of assumptions at the outset, again for the sake of time. I'd like you to assume that the right to privacy is customary international law. I'd like you to accept that it's not an absolute right, that derogations are permitted. I'd like you to accept that the right to privacy is a component of an overall human rights framework, which, as we all know, is interconnected and interdependent. Unlike practically every other human right, the right to privacy received almost no attention by the UN or its human rights treaties organisations for almost 2 generations. The Human Rights Committee issued a general comment on Article 17 of the ICCPR in 1988. Today it reads like a document written on a Grecian urn. With the possible exception of John Ruggie's work on business and human rights, the information age, the most far-reaching economic revolution ever, appeared to have escaped the attention of the UN and its treaty bodies until 2013, when Resolution 68167 was passed by the General Assembly, and the subsequent report the resolution authorised the High Commissioner for Human Rights to undertake, the right to privacy in the digital age, was published only a few months ago. Although the Digital Age report is primarily a response to concerns about mass surveillance, its conclusions resonate with a number of matters that have been discussed at this conference. One of the things it says is, effectively addressing the challenges relating to the right to privacy in the context of modern communication technology will require an ongoing, concerted multi-stakeholder engagement. This process should include a dialogue involving all interested stakeholders, including member states, civil society, scientific and technical communities, the business sector, academics and human rights experts. Leadership will be critical to ensuring these technologies are used to deliver on their potential towards the improved enjoyment of the human rights enshrined in the international legal framework. I think one of the key points the High Commissioner wishes to emphasise and that we should note is that the challenge raised by technologies such as the Internet of Things and big data require a multi-dimensional, multi-stakeholder approach where we as privacy regulators have a key but not the only role to play. I want to turn to the right to health. As many of you would know, the right to health is embodied in Article 12 of the International Covenant of Economic, Social and Cultural Rights. And it says this: the states parties to the present covenant recognise the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. Article 2 of ICESCA is the obligation of state parties to progressively realise the rights in the covenant. That obligation is essentially to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realisation of the rights recognised in the present covenant by all appropriate means. General comment 14 on the right to health says a range of things, and for the sake of brevity, it says that the right to health involves 3 dimensions: the obligation to respect, protect and fulfil. in the right to health. In turn, the obligation to fulfil contains obligations to facilitate, provide and promote. The Council has this to say about the obligation. The obligation to fulfil requires states, inter alia, to take positive measures that enable and assist individuals and communities to enjoy the right to health. States parties are also obliged to fulfil, provide, a specific right contained in the Covenant when individuals or a group are unable, for reasons beyond their control, to realise that right. The obligation to fulfil, promote, the right to health requires states to undertake actions that create, maintain and restore the health of the population. Such obligations include fostering recognition of factors favouring positive health results, e.g. through research and the provision of information. And it goes through, without quoting in full the general comment, some of the key issues that the provision of information play in fulfilling the right to health. Most privacy legislation attempts to reconcile privacy and health rights by embodying health-related exceptions to regulation over the use and disclosure of personal or health information, say when there's an imminent risk of harm to an individual. But this isn't a narrow exception that doesn't address key issues about how do you go about addressing the right to health, which by definition requires health information, whilst at the same time respecting, protecting and fulfilling the right to privacy. This is a classic case for applying privacy by design methodologies. Privacy by design is precisely the technique to use because it cuts through the zero-sum game arguments to show how a variety of public policy outcomes can be addressed to create public value. So we have two rights to provide. We have two rights to respect, protect and fulfil, health and privacy. They are interrelated and interdependent. So please bear that in mind. I then want to turn briefly to de-identification, and I acknowledge that I'm stepping into a highly contested area and that many assert that de-identification is a privacy dead end, that in a surprising amount of cases it's easy to re-identify de-identified information. Many examples have been given. A classic one is the Governor of Massachusetts, whose identity was re-identified from an attack on 135,000 claims data records held by the Group Insurance Commission in Massachusetts by matching the records with a voter registration list. Two fields matched, zip code and gender. There are plenty of other examples. Netflix is one through giving movie ratings. Closer to my home, my hometown of Melbourne, knowledge of four things produces some surprising results. So if you knew in relation to a particular individual the gender, in this case female, her date of birth, the 28th of May 1968, her residential postcode, which is a suburb called Camberwell, its number is 3124, and the final piece of information being breast cancer diagnosis, there is only one person who satisfies that description, and it's Kylie Minogue. There are other examples. I should be so lucky. These and other examples have led to claims in a range of academic studies that privacy cannot be protected by de-identification. They also assert that changes in society and technology mean that re-identification is easier and cheaper than ever. In the health sphere, it's argued that some established de-identification standards are weak. For example, the US HIPAA Act excludes de-identified information from regulation and sets out two de-identification standards, the Safe Harbour Standard and the Statistical Standard. The Safe Harbour Standard requires the deletion of a possible 18 data sets, but even this approach, it's asserted, is somewhat insufficient. Examples of these have led to suggestions that de-identification as a tool to protect health privacy is futile. This in turn has generated an atmosphere that undermines trust and encourages data custodians from attempting to de-identify personal information before making it available for secondary use. My comment in relation to this is that nothing is risk-free, and I note the comments of the panel before and the debate that went on in relation to risk, and concerns that risk analysis attenuates fundamental rights. I'd perhaps ask you to consider another analogy, and that is security. For the last 5 years, I think I've been the only statute-based regulator of protective security in the law enforcement field in the world. It's interesting. We still say to each other, yes, we must have better security methods. We must analyse security risks and remediate them. It's interesting that that argument doesn't seem to transfer into or to be thought as significantly relevant in the health sphere. In my view, a search for perfect solutions is simply unrealistic. We work within an environment where we're all required to manage risk. The fact that risks sometimes materialise doesn't mean that we do not adopt means to minimise it. For example, occupational health and safety laws. We all work within varying regimes about that. We all work within varying regimes about consumer safety. The fact that people breach the law or breach standards and norms is no argument, particularly if one takes a rights-based approach, for abandoning rights. Should privacy law be changed to include de-identified personal information? At first blush, this seems to be a good idea, but I'd caution that care needs to be exercised with this approach, particularly when you look at the public policy issues that surround it. It's actually a risk management disincentive, transferring responsibility from participants through to regulators. In my view, it's disempowering. It's also an unnecessary regulatory drag that doesn't necessarily produce corresponding benefits. Obtaining informed consent is expensive and often impossible. Informed consent is premised on a point of time. If a research project changes scope even slightly, the consent process needs to occur again. In any event, obtaining consent can often have substantial negative impacts on the quality of health research. Those who consent often have very different characteristics to those who refuse to consent. What does privacy by design suggest that we do? At its core, I have a message, please wrap up, so I won't deal with Australia. I have 3 more paragraphs. At its core, privacy by design asks us to manage risk according to a set of principles. It doesn't mandate a cookie-cutter, one-size-fits-all approach. It does provide the intellectual framework to assist us to analyse privacy problems. It particularly mandates a risk management approach. Clearly, we need to work constructively with those who have a relevant expertise, statisticians, cryptographers, computing scientists, to develop robust de-identification standards and to ensure that these remain fresh and relevant as technology advances. Finally, the health sector, from my experience, lacks a robust and effective understanding of governance. And I'd like to commend the comments that Alan Chang made on the first day about the centrality of governance to privacy protection, because I believe that that's absolutely the case. Good governance involves good risk management, and privacy is a risk. It's a right as well, but it's also a risk. Frequently, health research structures are a complete shambles. Poorly documented, unincorporated joint ventures that lack accountability, directed by time-poor researchers who have no governance training and whose role is compromised by funding agreements, employment relationships that override their independence and conflict of interest. I thank you for your attention. I'm very happy to answer questions at the appropriate time. Thank you.
About 8 minutes, the 2 more speakers, and then we're going to have some questions and discussion with the audience. So this is Mukesh Haikraval from the World Medical Association.
Good afternoon, and I'd like to thank the organisers for inviting me to this prestigious conference. In particular, I'd like to thank Malcolm Crompton for taking a risk by suggesting me. He might have thought that was a bit of light relief for you. My name is Mukesh Haikerwal, and I'm a general medical practitioner in Melbourne, Australia. In fact, very close to where David comes from. We haven't seen each other for months, but I actually work in communities with him. Interesting. Hi, David. Nice to see you. I'm here today because I have the honor of being the chair of the Council of the World Medical Association. Our organization has